ahead, please, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 20. I pray for 2 weeks' time, Your Lordship.
No objection, Your Lordship.
How long?
2 weeks' time, Your Lordship.
On pray made by the petitioner. List this matter up to 2 weeks.
Highly obliged. Day.
May it please Your Lordship, I beg to mention item number 14, my lord. If this matter may come up after 2 weeks, my lord.
Who is for the petitioner?
I'm for the petitioner, my lord.
What is this matter about?
This is, my lord, petitioner was. This is related to service, my lord. Petitioner had applied for a post. My lord, on the first round, my lord, it was rejected, saying that his domicile certificate is fake, my lord. So thereafter, we had approached this honorable court because they came to a finding, my lord, this domicile certificate was genuine. On that basis, there was a direction from this honorable court to allow him to participate, my lord. So thereafter, he participated, my lord. However, in the trade test, my lord, the marks which he got, my lord, so he was declared unsuccessful, my lord. So that we have challenged, my lord.
Where's the nullified data?
My lord, nullified is there, my lord. I'll point it out, my lord.
Those would be issues of facts.
Issues of facts, my lord. Facts and as well as certain issues of law as well, my lord.
On pray made by the respondent. List this matter up to 2 weeks.
Much obliged.
My lord, I beg to mention item number 16, my lord. That TT Dingdo is from the opposite side. My lord, I am praying for 2 weeks' time to file my written synopsis, my lord. Because pleadings has been completed, arguments concluded, only my written synopsis of my argument. I'll be filing after 2 weeks, my lord.
On pray made by the respondent, state respondent, not objected to by petitioner. List this matter up to 2 weeks.
May I please, Lordship? My lord, I beg to mention item number 11 and 13, my lord.
One at a time.
My lord,
What is 11?
it is with regards to the dismissal from service, my lord, item number 11, my lord. And item number 13 is with regards to ACP and MSCP, my lord.
Related?
No, my lord, both are different.
So 1 at a time.
Different, my lord.
This matter has been heard.
No, my lord, no, my lord.
So your promotion has been withheld.
Promotion has not been withheld, my lord. They are seeking for ACP, grant of ACP, my lord.
Okay.
My lord.
Oh, grant.
Grant of
That is 13, my lord. 11 is dismissal.
11 is dismissal from service.
Dismissal. On pray made by the petitioner. List this matter up to 2 weeks. 13. 13. You are there. Same.
Thank you. My lord, number 19, I am required to file an affidavit, my lord. This is praying for 10 days' time, my lord. This matter was heard. The learned counsel from Delhi argued the matter through online.
Oh,
on the
that.
last occasion, my lord.
Section 4.
Turned approver, my lord. The complainant has been made approver in this matter.
Yes, yes, yes.
So 1 week or 10 days' time, my lord.
You have to file an affidavit.
Affidavit, my lord. That's the last order, my lord.
I think a legal issue is involved.
Only to the fact whether what is the stand of CBI, my lord.
Okay.
Court allowed approval, my lord, on the application by the complainant, my lord. Now, the counsel for the petitioner wanted to know what is the exact stand of the CBI, my lord. Though in the order is reflected that CBI is not opposing that, my lord. CBI didn't oppose before the trial court.
On pray made by Leonard DSGI, who has sought for some time to file the affidavit in this matter, for some more time to file the affidavit in this matter. The matter is adjourned. This is after 3 weeks.
Please, Your Lordship, I beg to mention item number 15.
What is required here?
To file written arguments. Matter has been heard.
On
Pray for
payment
2
by the
weeks.
petitioner, list this matter for 2 weeks.
2 weeks.
Lordship, seek your permission to make a mention of item 12.
We've paid that amount of 8 lakhs. The matter, they've received the amount. So the matter can be closed, Lordship.
In fact, we received the payment last year itself. I had made a mention.
But we couldn't get the receipt, we couldn't get the agreement.
We've received the money, so we are no longer interested in pursuing.
You are the respondent.
Respondent.
So how do we go about it? You withdraw the appeal.
No, the matter, not withdrawal, Lordship, can be closed?
Can be closed upon settlement arrived.
Settlement arrived.
That has to be on record then.
Lordship is rightly said. That is the reason the matter was lingering on for such a long time, because we couldn't get the
It
settlement.
appears, Mr. General, either you have not received any material instructions in the same.
That's a fact.
Otherwise, you've been linked on.
My lord, the check was handed over to my hand, so I know for a fact that we have received the money, my lord.
What Lordship
talking
is
about you.
material instruction, Lordship.
With stress on the word material, I appreciate that. No,
Despite the fact it was settled last year and still, Lordship.
Let the matter come up. Let the matter be heard.
otherwise, if lordship allows, if lordship chooses, if lordship is asking for some sort of a settlement agreement, we can prepare one and file one.
But this is not the time to make such submission. Here is only when this is mentioning hour.
Lordship, so
Only if you have,
Let the matter come up, Lordship.
matters urgent, you need some time to file this, that, or seek adjournment.
So let the matter come up.
if lordship allows us 2 weeks time to file a settlement agreement, that should be enough.
On premiere with the parties, list this matter to 2 weeks.
Lordship, I beg to mention item number 18. 18.
Lordship, in this matter, oral arguments was already been advanced. The respondent have been taking time for filing the written arguments.
Have you filed yours?
We have already filed. Now it's been
Those,
3 to 4 times, Lordship.
Those, what do they call it?
Pardon, Your Lordship.
The subject matter?
Lordship, with regard to the question of that FIR regarding that grinding balls,
Hey, grinding balls.
that civil matter.
Lordship, I
Lordship,
just need
for
2 more
almost
days, Your Lordship.
4 to 5 occasions they have taken time. Now Your Lordship will
The
even...
FIR was filed by you.
Lordship,
FIR was filed by you.
complain, Your Lordship.
Yes.
Complain.
They file a
FIR
complaint,
was-
Your
Sorry,
Lordship.
complaint.
Yes.
Just need 2 more days, Your Lordship. Kindly grant 2 more days.
On premiere by the respondent, this is matter of the 2 weeks.
Lordship,
But
not
last
further
chance.
time because Your Lordship will even forget the oral arguments, perhaps.
But you have filed your
Almost
written.
already filed, Your Lordship. It's
Do
already
it,
on record.
do it.
Yes, Lordship.
Item number 1.
Mr. Bora?
Yes,
You
ma'am.
appearing in person? You are the petitioner?
Yes, ma'am.
Appearing in person?
Yes, ma'am.
Are you competent to appear in person?
Yes, my lord.
Are you competent to appear in person?
Yes, my lord.
Look at your attire.
Yes, yes. This.
By now you should know. Mr. Bora.
May I please, my lord?
Tell me.
My lord, the revision is against the Jimma order passed by the court below. The case was that from 10 July to 12 July, during these 3 days, answering to an advertisement in the Facebook through Meghalaya OLX group, I had paid a sum of rupees 2,57,649 for purchase of a Bolero vehicle, which was published, which was advertised through the Meghalaya OLX group. After payment of that also, they had not sent the vehicle and they cut off the link. Then I suspected through other means also with contacts in Guwahati also that they had impersonated as Indian Army people while contacting me. So I went to after knowing that it is a cybercrime committed, I went to the cyber cell of the DGP's office, lodged a complaint. So under instruction of the cyber cell, I lodged a formal FIR before the Sadar PS, which was registered as 167 of 2022. Then for about 5-6 months, there was nothing found. I was in contact with the IO, nothing was found. Then thereafter, I filed one writ petition. Under order of the writ court, the investigation speeded up, and ultimately the person having the custody of the vehicle surrendered the vehicle along with the documents before the Sadar PS. Thereafter, one petitioner came. My lord, last page, that is page number 35, I think. 35A, oh no. Yes, page 32, my lord, is the order of the court below, passed on 8/5/2023, where Sierra put up today, etc., seen and perused Jimma application, etc., filed by petitioner Sri Jagat Brahma. So this Jagat Brahma applied for Jimma, and then the court below called for the IO's report.
So he claimed to be the owner of the vehicle.
Owner of the vehicle.
Which was actually purchased by you.
Yes, I had purchased. And what happened actually, when I had made the payments, the owner was one Tafazul Hussain. He was the registered owner. After stopping the connection, immediately within few days, the vehicle was sold to this person.
Oh.
Fraudulently, just to evade me. So this person came with the vehicle to the Thana. Now he applied for Jimma. And the court below passed order for calling for IO's report. On the next date, on the 9th, IO's report came, and IO also opined that vehicle could be given on Jimma. So on the opinion of the IO, the court below allowed the Jimma, and on 12/5/2023, the vehicle was released on the surety of 50,000 rupees. My point of contention are the grounds I have enumerated from page 7 of my petition onwards. Under para 11A, for that, the impugn order of...
Have you read the so-called petitioner owner?
Yes, my lord. He is the respondent too. And those who are supposed to be aiding him in the crime, yes, I have made them pro forma respondents now because their identities have not been disclosed yet.
Who's appearing?
Worship, I'm entering appearance on behalf of the state.
State is not a party here.
Yes, my lord, it is here.
Is it?
Yes, state of Meghalaya is number 1, respondent number 1.
The owner...
Yes. So state of Meghalaya is a party. Then we have respondent 2 and the pro forma respondents.
Yes.
So you take steps, Mr.
Yes, ma'am.
Heard Mr. P.K. Bora, petitioner in person.
Much obliged, ma'am.
The state is represented by Leonard G. Miss. What should we call it? Mr. Bora, we have a cup of tea waiting for you.
I'll have later.
It is getting cold, so you have to hurry. I was looking at the paper and this is not the first time you have done this. Unauthorized? Since there are other respondents in the arrayed in this petition, the petitioner is directed to take steps for issue of notice upon the respondents 2, 3, 4, 5, 6 and 7 respectively. Notice returnable within 2 weeks. Less the matter thereafter.
It's anticipatory bill, my lord. This is a company matter, my lord, where the petitioner is a director of a company that has gone into liquidation, my lord, and the matter is pending before NCLT. I submitted on last occasion, my lord, because the sections are very all below 7 years, my lord. So whether 41A notice was issued or not.
What are your instructions?
My lord, the state is to take instruction.
No, but you are to, if at all.
My case was that we have not received any 41.
You have not received, so that's it. Yes, Mr.
Lordship, I have received instructions for the same, my lord, and the instructions are quite long. Your lordship would prefer read, lordship.
What are the instructions?
Instructions are that they have searched for the applicant 2 times to serve notice, my lord, but both times they have not met him. The instructions are very clear over here, lordship.
Oh, he is not a local.
He's from Guwahati.
He's from Guwahati, lordship, and they went to Guwahati 2 times.
He doesn't have a a correct address or some sort of identification.
The address is correct, lordship. Actually, the police, along with the local police in Assam, they had gone there, lordship. They met the wife, but then they could not serve the notice to her because the applicant himself was not present, lordship. So actually, the visit of the police was just to serve notice under section 41, my lord.
So you should have you advise your client to accept notice.
But when was the police came that much he knows.
That's what the Learned Council has said.
Lordship.
Yes, for the purpose of serving notice on the 41.
But my lord, recently I have come across one decision of Karnataka High Court, my lord, which says that even after 41A notice, anticipatory bail is maintainable, my lord, because the apprehension of arrest does not.
No, we'll deal with that first.
Yes.
See, because section 41 does not necessarily mean the police can arrest you. They give you an opportunity to be heard.
My lord.
And if there are grounds for your arrest, they will indicate. Thereafter, at that point of time, you can come before the court with an appropriate application.
Lordship.
But the apprehension is that when he goes to record or pursuant to, he responds to 41A notice going to police station, my lord.
That cannot be.
It cannot be, my lord. That's a misconception.
Section 41 is very clear.
Yes.
But that has happened, my lord, recently.
That is a different thing. If it happens, then we will deal with the matter as and when it comes out. But the court will come very heavily on the whoever has flouted such norms.
Procedure has to be followed, my lord.
In fact, my lord, that was there's a lot of this 41A notice. What is the purport of 41A notice, my lord? In fact, I got a judgment from Telangana High Court that which says that once 41A notice has been issued, without magistrate's order, police cannot arrest.
Cannot arrest,
my lord. Police has to obtain an order from magistrate, my lord. I just point out that order, my lord.
Yeah, well, we have not reached that stage here.
Exactly. Because in Meghalaya there is no clarity on this, my lord. What is the import of 41A notice? Because people are even now apprehensive that if you go responding to 41A notice, he may be arrested.
See, the fact remains, by and large, whenever police comes, the apprehension is always there. So people, even without knowing the actual reason, whether police have come to question them or to arrest them or to serve notice, they will always say, police have come and run away. So that is generally the apprehension. Of course, it could be because of the level of intelligence or understanding, whatever the case may be. But the law is very clear that once, if a matter or offence involves 7 years and below punishment, then Section 41 A has to be compulsorily or mandatorily applied or served. Once it is served, it's incumbent upon the police to file his report, which also gives you an opportunity to know your position. Like I said again, at that point of time, you can always approach the court for anticipatory bail or regular bail, whatever the case may be, but not prior to that. In fact, when it is in this case, when it has been submitted at the bar that the intention of the police is only to serve you the notice under 41, then you accept it.
Well, we'll accept it. Only that submission is recorded, my lord, at least.
No,
because
you accept it, and the direction will be that
my lord, he himself, without 41A notice, he'll present himself tomorrow itself, my lord. Before the Ayush, there's absolutely no problem with that, my lord. Only the fear, apprehension of arrest, my lord.
Let the formalities be completed.
That much observation, my lord, the attempt was only to serve 41A notice or no apprehension of arrest, my lord, at this stage.
Lordship, I can read the entire instructions if my lordship would like to hear, or because he's still apprehending. Actually, it's very clear over
This
here,
has happened, my lord, that's why I'm apprehending,
lordship, that they had gone there to serve notice, but only the wife of the applicant was there, and she refused to answer his as to where his whereabouts were. So that's the only reason, lordship, 2 times.
Well, my instruction is that the 4 or 5 police personnel came, my lord, to serve 41A notice, my lord. I think one person is enough.
From Reboy, if I may, lordship, from Reboy, along with local police over there, they cannot go by themselves, lordship. They have to take the assistance of the local police. So maybe that would result in maybe 2 plus 2. That's all, lordship. And along with female police officers also, lordship.
Well, my lord, my case here, my lord, under the Insolvency and Bankruptcy Code, there is a specific provision, my lord, and they have already moved. The complainant has already moved the tribunal, my lord, for that. My lord, once they are trying to seek parallel remedies, my lord. There is a specific provision under the Bankruptcy Code, my lord, that in this kind of situation, how an application can be filed before NCLT, and NCLT will pass an appropriate order. Now the complainant has already filed an application before NCLT. I have placed on record, my lord.
Lordship, whether
And in
that
spite
is
of that, my lord, that now filing a 420 has become an omnibus section, my lord. Anywhere go and claim 420 and 420 is 7 years, my lord. Go and arrest anybody.
That should be raised before a trial court, lordship. At this stage, lordship, we are just on the.
No, these are relevant considerations for bail application, my lord.
Anticipatory bail, lordship, which we are not. There is no intent to arrest right now, lordship. As your lordship has rightly pointed out, if there are reasons, then it will be made known, lordship.
That much one sentence observation is recorded, my lord. At least we will feel safe, my lord. That there is no intention to arrest.
Lordship, not that there's no intention to arrest.
That would be
exactly
that's the outcome of the investigation, of course.
Lordship, the only intent of the police going to the house of the applicant is just to serve notice under section 41A, lordship.
Let us read what 41A says.
Lordship.
Please.
Lordship. Lordship, 41A, notice of appearance before police officer, lordship. The police officer shall, in all cases where the arrest of a person is not required under the provisions of subsection 1 of section 41, issue a notice directing the person against whom a reasonable complaint has been made, or credible information has been received, or a reasonable suspicion exists that he has committed a cognizable offence, to appear before him or at such other place as may be specified in the notice. Lordship, if I may jump subsection 2 to 3, where such person complies and continues to comply with the notice, he shall not be arrested in respect of the offence referred to in the notice unless, for reasons to be recorded, the police officer is of the opinion that he ought to be arrested. So once he complies, lordship, the section is very, very explicitly clear.
Well, the second part of the sentence, unless reasons to be recorded. Well, reasons recording is
after statement has been taken. Lordship, just because the offence is under 7 years, Lordship, doesn't mean that they'll never be arrested, Lordship. It's subject to reasons recorded, Lordship. They cannot come over here and make the plea that nobody can be arrested. That's what my learned senior is coming at, Lordship.
My friend is not going to concede. I'm praying for I've come under 438 for anticipatory bail.
If I may just complete. So, Lordship, over here, unless for reasons recorded, we are there just to serve notice, Lordship. I don't understand what is the anticipation about, Lordship. It's just for service of notice, which has, I can directly say, which has been declined because even the wife of the applicant refused to divulge his whereabouts.
Lordship, see subsection 4, my lord. Subsection 4, that is what has been interpreted by Telangana High Court, my lord. Subsection 4 says, my lord, where such person at any time fails to comply with the terms of the notice or is unwilling to identify himself, the police officer may, subject to such orders as may have been passed by the competent court in this behalf, arrest him for the offence mentioned in the notice.
This is also after service of notice, Lordship.
Yes, of course. This is if he is not willing to cooperate and all.
Exactly,
But
Lordship.
in your case, it's a different thing.
So, notice has not even been served yet, Lordship, over here.
My lord, here what is happening, my lord? I'll just place, my lord, this is the Telangana High Court.
Copy for me.
Well, para 5, my lord.
Yes.
This court has already directed the Director General of Police to frame guidelines with regard to issuance of acknowledgement in the cases where accused persons before the police under Section 41A CRPC, and the same cannot be at the whims and fancies of the police. If the accused feels that the police failed to follow the procedure under Section 41A CRPC or the guidelines of the Apex Court in Ernest Kumar's case, they could as well come before this court by filing contempt petition against the concerned police officer with relevant material to substantiate their allegations. But on this basis, they cannot seek anticipatory bail. It is appropriate to mention that after issuance of notice under Section 41A CRPC, if the police feels that the accused has to be arrested, without obtaining the permission from magistrate concerned, they cannot arrest the accused.
That itself does not cover the instant application here, Lordship.
So-
This is all after service.
So, in that case, see,
My lord, my submission that this has not been let down by this honorable court and this is not being followed in Meghalaya, my lord.
How can you make that statement?
My lord, if lordship permits, I can file an affidavit, my lord, indicating that after 41A notice, a person has been arrested.
Lordship,
by-
he's going to
by
a
the
wider
police.
arena over here, Lordship.
Can
He's
I
come
just
with
complete my
anticipatory bail.
Can I just complete my argument? So, my lord, as transpires, my lord, there is no assurance even by the state, my lord, that if I go on 41A notice, I'll not be arrested, my lord.
see, read the last part of that paragraph. It says, if the police feels that the accused has to be arrested without obtaining the permission from the magistrate concerned,
They cannot arrest
cannot.
the accused.
So,
My lord, this is not been followed.
that's condition precedent.
My lord, this is the interpretation given by Telangana High Court, my lord. In Meghalaya, we do not have any such observation by this honorable court, my lord.
Okay.
As on today, my lord. And there are cases, I can file an affidavit bringing on record that when a person responding to 41A notice went to police station, my lord, he was arrested.
That could be the case, yes.
Whether this instant application would cover over there, Lordship, he's going to other cases now. He can file a PIL in that case then. Lordship, this is just an anticipatory bail by the applicant before this honorable court, Lordship. It's got nothing to do with the case law referred to by my learned friend, Lordship, because over here notice has not even been served. The case he's referring to is after service of notice, Lordship.
No, but this would certainly answer to the issue of apprehension.
And my Lordship,
If at all, even after service of
Lordship,
notice under
yes.
41A,
Yes, Lordship.
as provided in the provision itself or the statute,
Yes.
the police are of the opinion that he is to be arrested.
For reasons to be recorded,
For reason
Lordship.
to be recorded. They will record. So how do we know that they will not record their reasons then and there
Then they record and they arrest, my
and
lord.
arrest him then and there?
Lordship.
There is no guidelines to that matter has been pointed out. So to that extent, safeguard should be there for the petitioner, because generally the concept of 41A is to conduct an inquiry, get the cooperation of the petitioner or whoever is concerned, and thereafter form the IO will form his opinion.
Yes. But Lordship, my Lord.
But the arrest per se
Lordship.
cannot be done.
But
41A.
My Lord, at subsection 3, where such person complies and continues to comply with the notice, Lordship.
Yes.
Yes.
So if he fails to comply, then you can arrest him.
Lordship. Then only.
So that stage, we have not reached that stage.
We have not reached, Lordship. We've not even been able to
My lord,
serve,
that
Lordship.
is where the loophole is for the police, my lord. My lord, in the section 41A notice, they follow the prescribed format of Delhi police, my lord. Delhi police issued a format, my lord. There are 10 clauses in that. You will not tamper with evidence, you will not abscond, you will do this. Now, to find fault with any of those 10 clauses, my lord, the police can do at any point of time, my lord. But no, you have not cooperated, you have not done this, you have not done this, and come, we arrest you. My lord, the safeguard, Arnesh Kumar, the safeguards were provided, my lord, for a larger reason, my lord. And that's how the Telangana High Court is. My lord,
where is the Arnesh Kumar case? Tell me whether it says about the only the part of apprehension after 41A is done.
well, para 7.1, I just read, my lord, the books.
Please hear.
In para 7, they quote section 41, my lord. Then it says, from a plain reading of the aforesaid provision, it is evident that a person accused of an offence punishable with imprisonment for a term which may be less than 7 years or may extend to 7 years, with or without fine, cannot be arrested by the police officer only on his satisfaction that such person had committed the offence punishable as aforesaid. A police officer before arrest in such cases has to be further satisfied that such arrest is necessary to prevent such person from committing any further offence or for proper investigation of the case, or to prevent the accused from causing the evidence of the offence to disappear, or tampering with such evidence in any manner, or to prevent such person from making any inducement, threat, or promise to a witness so as to dissuade him from disclosing such facts to the court or the police officer, or unless such accused person is arrested, his presence in the court whenever required cannot be ensured. These are the conclusions which one may reach based on facts. The law mandates the police officer to state the facts and record the reasons in writing which led him to come to a conclusion covered by any of the provisions aforesaid while making such arrest. The law further requires the police officers to record the reason in writing for not making the arrest. In Pith and Core, the police officer before arrest must put a question to himself: why arrest? It is really required. What purpose it will serve? What object it will achieve? It is only after these questions are addressed and one or the other conditions as enumerated above is satisfied, the power of arrest needs to be exercised. In fine, before arrest, first the police officer should have reasons to believe on the basis of information and material that the accused has committed the offence. Apart from this, the police officer has to be satisfied further that the arrest is necessary for one or more purposes envisaged in subclause A to E of clause 1 of section 41.
Lordship, if I may also read, Lordship, the same case law. We are of the opinion that if the provisions of section 41
You are reading what portion?
Lordship, I'm sorry, Lordship, online there's no paragraph, Lordship, but it's near towards the end. Para 10, Lordship. We are of the opinion that if the provisions of section 41 CRPC which authorizes the police officer to arrest an accused without an order from a magistrate and without a warrant, are scrupulously enforced. The wrong committed by the police officers intentionally or unwittingly would be reversed, and the number of cases would come to the court for grant of anticipatory bail will substantially reduce. We would like to emphasize that the practice of mechanically reproducing in the case diary all or more of the reasons contained in section 41 for effecting arrest be discouraged and discontinued. Our endeavor in this judgment is to ensure that the police officers do not arrest accused unnecessarily, and magistrate do not authorize detention casually and mechanically. In order to ensure that we have observed the above, we give the following direction. All the state governments to instruct police officers not to automatically arrest when the case under section 498A is registered, but to satisfy themselves about the necessity for arrest under the parameters laid down after flowing from 41 CRPC. All police officers be provided with a checklist containing specified subclauses under section 41, clause B, clause 1, section 1, subsection 1, clause B2. The police officer shall forward the checklist duly filled and furnish the reasons and materials which necessitated the arrest while forwarding and producing the accused before the magistrate for further detention. Lordship, this is very clear, Lordship, that the case of Arnish Kumar covers as to what will happen if there's any arrest made before issuance of notice under section 41. It's laid down in a very lengthy manner, Lordship. So for a submission to be made that, Lordship, if the arrest is made when the person who's accused comes and make a statement before the concerned police officer, Lordship, actually the police officer has to record, and the magistrate has to give the acceptance for such recording and also for arrest of that person, Lordship. It's very clear, Lordship. So we cannot say that in one state it's being followed, in one state it's not being followed, Lordship.
In this judgment, the exact situation has not been
dealt with,
has not been addressed, except that a caution has been made
Cautions
to
given,
the,
Lordship,
to the magistrate concerned
and the police
and police
officers.
officer in case of arrest, what they are required to do, to draw up a checklist and so on and so forth.
Lordship.
But this situation, my lord, went for 41A and anticipatory bail, my lord. This has not been dealt with.
This has not been dealt with.
This judgment. So Lordship kindly goes to peruse the Karnataka High Court judgment which I placed, my lord. This will throw some light on this. My lord.
We'll have to address this issue.
Your Lordship address this issue once for all, my lord.
It's a fluid situation, where the power of arrest naturally is given to the police, and in the event a situation where notice has been issued under 41A is there, what should be the conduct of the, and also we have to also to look at the version of the petitioner who has come before the court, competent court, with a prayer for grant of pre-arrest or anticipatory bail. That has to be addressed.
If that is addressed, that will solve a lot of problems in the statement.
We'll do one thing, we'll keep this matter after 1 week. You go through relevant authorities.
I'll do that.
Find out. Similarly, only on that limited issue.
Only on that point.
That would answer a lot of
There
questions.
should be clarity, my lord.
Just to
If
get
there's a clarity that after 41A there is no threat of arrest without magistrate's order, then at least accused person is free, my lord.
True.
Let my friend also supply copies of his.
Please do that. Heard and counsel for the parties. This is matter for hearing after 1 week. 1 week?
Much obliged, Lordship.
In the meantime, the interim order passed by order dated 21/6/2023 shall continue until further orders.
The same order in item number 7 also, my lord.
Same.
Lordship, in item 7, the police have served notice on under 41A.
It's connected matter, Lordship, 7 and 2.
Received.
Received, Lordship.
So, my lord, the legal issue will come together,
The
my lord.
legals of 41A will take its process, Lordship.
True, but that will see after service of the notice, then the report will follow. The report will follow. So we don't know what will be the report. Either he will be let off without being arrested, or there may be reasons for him to be arrested. So still that question, when the matter is pending for grant of anticipatory bail, is there.
Lordship.
We'll look into this issue.
My lord. My lord, if I may, my lord, on the 12th I'll be out of station. If it can be fixed, Lordship, on the 13th maybe? Wednesday? Thursday?
Thursday.
Fine. Let's this matter on 13.
Much obliged, Lordship.
Much.
Item number 3.
Not the interim order in item number 7 also.
Same order.
Much.
I am appearing for the sole respondent, my lord, item number 8. And,
Item number?
The petitioner.
You are for the petitioner?
No, I am for the respondent.
Who is
my
for the
lord.
petitioner?
Oh, sorry. I'm sorry.
May I please, your lordship?
Yes.
My lord, this matter is connected to, my lord, criminal petition number 36 and 37, lordship. In fact, this matter is coming up on 13th of July, lordship. This is connected by 13th.
Mr. Salman Khurshid, my lord, argued the matter.
Okay.
So, Mr. Khurshid argued for accused Ampurin Lingdom, my lord, and the other accused is come. It's identical questions of law, my lord. Those matters are coming.
But they may have their own, version.
My lord.
The one or two grounds may be different, lordship, but it's connected matter, lordship. Most of the grounds will be same, lordship.
Heard Mr. Espanthi, learned counsel for the petitioner. Dr. N. Muzika, learned DSGI, has accepted notice on behalf of the respondent. It is submitted that the issue related in this instant application is similar to the issue. Do you have the case number?
Lordship, I have 36 and 37, lordship.
Criminal petition 36 of 23 and criminal petition 37 of 23.
To the issue involved in criminal petition number 36 of 2023 and criminal petition number 37 of 2023, both cases being pending before this court. Accordingly, the prayer of the parties is that this case may be listed on the same day. The said cases, the aforementioned cases, are listed, that is on 13 July 2023.
Obliged.
Accordingly, as prayed for, this is matter on 13 July.
Much. Three and four.
Same.
3, 4. Come with 36 and 37.
Item number 5.
Lordship, in this matter, I'm bringing some more time, Lordship, for filing the rejoinder. Actually, Lordship, the concerned person who handled the matter he's unwell, Lordship. So there's a problem.
This is with regard to
Withdrawal of that notification, Lordship.
notification as far as
They have challenged the notification that was issued, my lord.
as far as the EPF is concerned.
My lord.
I'm praying for 3 weeks' time, Lord.
We are for 1 and 2.
The company is still functioning.
No, Lordship, as of now, we have been suspended, Lordship.
Suspended
Yes, Lordship.
because of this issue.
No, Lordship.
No, my lord. The condition is back, my lord. The financial condition.
So what happens? Are they still employees? Are they still working? Are they still getting paid? Are they still
That
contributing?
I'm not aware, my lord.
Lordship, I have no.
Some other cases are also pending where I am appearing, my lord. It's Komoro limestone.
Kamara limestone.
But here what happened, my lord? They were lessee of a limestone bearing land in Cherrapunji side, my lord. Now what has happened? They had a lease over 200 acres of land, something. Now because of the minor mineral, major mineral, lots of dealt in the division bench, my lord. Some minor mineral leases were given out of the same land by the state government to other private parties.
Okay.
So when Indian Bureau of Mines, whom I represent, my lord, they came to know about this. From the same land, there cannot be 2 leases, my lord. One lessee is Komora and there are some other private parties in people lease. So we suspended the mining lease, my lord, of this company. In the meantime, the lease itself is expired, my lord. The 30 years period is over.
So practically, of course, now we can, so the company is defunct now.
There are no operations, my lord. The mining operation is not there. Company will exist, my lord.
Company will exist, but
Operations are not there.
but are there still employees there? We are concerned about the employees.
Employees
Lordship,
should be there.
he will be is there, Lordship.
Should be there. Unless they are terminated, my lord.
Unless they are terminated.
Because that I'm not aware, my lord.
On prayer made by the petitioner, who has sought for some more time to file the rejoinder affidavit, the same is allowed. Let the rejoinder affidavit be filed within the next date fix. This is matter of 3 weeks.
You're obliged.
Obliged.
Item number 6.
My lord, I pray for 3 weeks' time, my lord. I'm appearing for the respondent in this case, my lord.
Lordship, I'm
You have
appearing
to
on
file
behalf
a
of
counter.
petitioners.
My lord.
You are for the.
I'm appearing on behalf of petitioners.
Is this that Lokayukta matter?
No, my lord. This is regarding ARPS school, my lord. That
Oh,
new
ARPS.
matter, yes.
Okay. On prayer made by the respondent, your respondent,
I'm for the ARPS school, my lord.
3 to 5. You don't even know yourself.
My lord,
On prayer made by the respondent, 3 to 5. Seeking time to file the counter affidavit. Same is allowed. It is noticed that the respondent 1 and 2 are not present. As prayed for, this is matter after 3 weeks.
obliged.
Item number 8.
My lord, here, my lord, I pray for 3 weeks, my lord.
What is it?
3 weeks, my lord, I pray.
Order. Hearing.
Oh, that
This
maintenance
can be
matter.
fixed for hearing, my lord.
Hearing, my lord. Let it come for hearing. We'll finish.
You are saying she is not your wife.
My lord, she is not entitled. That is my submission, my lord. She is not entitled.
Has she remarried?
My lord, that's first they are challenging the jurisdiction, my lord. There's a 125
Yes,
petition.
my lord,
That's
yeah.
basically that's challenging the jurisdiction, saying that the district, the normal court does not have a jurisdiction to entertain 125 petition. a maintenance petition under section 125 because it's being the tribals, only the tribal courts, the district council courts respective have the jurisdiction. They're saying that. But then I would like to reply with that the Kuntu Accords case that was there. The Kuntu Accord case is that yes, but if the tribals residing in the different districts, then the normal court will have jurisdiction. In this case, the lady Simli, her name is Simli, and she is a resident of Jowai, and she is not a Jaintia, a Panar. Subject to corrections, my lord. And then the man, the husband, is a resident of Mairang. So, two different.
As you see, we're talking about territorial jurisdiction, true, but not on the basis of of one's ethnic identity.
Ethnic identity, yes.
At a time of hearing, my lord, this issue can be looked at, my lord.
And it is also notice. Please correct me in this. As far as application under section 125 are concerned, for maintenance, some matters are being taken up by the regular courts, district court, and some are taken up by district council, even if parties are tribal. I don't know whether it's true or not.
Yes, it is going
some
on.
cases, my lord.
So isn't that an overlapping of jurisdiction?
Overlap. We'll try to research on those and then.
Is noticed. Just try to find out and
yes, my lord.
Guide this court on that.
My lord, we'll try.
On pre-made by the parties, this is matter of 2 weeks.
3 weeks, my lord.
3 weeks.
Item number 9.
My lord, we have taken step.
Please, Lordship. Lordship, in this matter, the petitioner, I humbly pray that he may be allowed to serve the notice through Dusty, Your Lordship, because we have taken step, but then we have not
See,
served.
Mr. Sangwan, I'm told I may be wrong also. There is no provision of service by Dusty. And what is Dusty, by the way?
Personal service.
Is it there in the rules?
No rules, but that is a
Lordship,
practice.
it's a practice, my lord, that we have carried down right from the then Honorable Guwahati High Court, Shillong Bench, Lordship.
But if it is not, in the rules, it's not mandatory, statutory. Can we,
Lordship,
just because it is a practice, can
this
we
is a
continue?
practice, Lordship.
But you see,
Personal.
because what happened is, if it is just a practice, and suppose you go and serve personally, and finally that person denies service, what do you do?
Then we file a report to the court
Brought on
saying
record,
that,
Lordship, a denial.
saying that you have not
No. He'll say that this is not a proper form of service. What do you say then?
No, actually, to Dusty, we just
But
submit, but
there-
it's
there-
going
there
from the
should-
court only.
There should be some, at least rules to that effect. There should be some rules. Because nowadays, service can be by email, it can be by WhatsApp,
WhatsApp also, Lordship.
by telephone, whatever, by mobile phone, whatever. So that, of course, is not there, but it is, these
WhatsApp, yes.
these processes are being contemplated to be included in the rule books.
Lordship.
But as of now, we don't have. And this concept of dusty, the court just go along with it. If there's a challenge to it, what do we do? So the safest option for you is to go by the usual process. Service of notice through post, by ID card, or we don't. I think we don't have rules. Not as it.
No, not for dusty,
by
Lordship.
WhatsApp, even by WhatsApp or email.
WhatsApp, actually, it's come down from the Honorable Supreme Court that if, especially during COVID time, Lordship, if the blue tick appears, that the person whom has received it, it is deemed to be served, Lordship. That is what's during COVID time, Lordship. That has come up.
You just, I think, you just
I will.
think about it. No specific order will be passed in that regard. But as far as this matter is concerned, you take fresh steps if required.
Yeah,
if you want to await service, or you take fresh steps.
Okay. Yes, still awaiting, Lordship.
So we'll wait. The counsel of the petitioner has submitted that the service report on the notice issued upon respondent 4 has not yet come. It is therefore prayed that the same may be awaited.
Lordship.
Pray aloud. This is matter to 2 weeks.
Lordship.
That's applied, Lordship.
Lordship.
Item number 17.
So how far have we progressed here?
Also, partly the matter was heard. Just to refresh the memory of the court, this is a revision petition against the concurrent finding of the court below.
Revision petition.
What has happened here also, before I go into the evidence, the petitioner here, a Nigerian national, was in India in Nigerian passport with valid visa. Now, Lordship, he had reported before the FRO Ceylon, Foreigner Registration Office. After reporting there, some of the officers therein, they found that the visas were extended 3 times, and the seal used in the 3 visas were different. 2 were similar, 1 was different. So they had a hunch that this must be a case of some forgery or something. So they contacted the issuing authority at Delhi, FRO Delhi, through fax message, whether such and such visa was issued by the said office. The Delhi FRO sent a fax message, saying that it is a forged one and visa was never issued to him. Consequent to which, based on this limited fax message, FIR was being filed before the SADRPS, and SADRPS submitted a charge sheet, and the accused was charged with section 468, 471, read with section 14 of the Foreigners Act. And also, when it comes to 468, it speaks about forgery, and 471 using a forged visa as genuine, a forged document as genuine.
Yes.
Four 68,
So
468, 471, read with section 14 of the Foreigners Act.
Foreigners Act.
Yes.
Yes.
Also, 468 and 471 is clear. Now, when it comes to section 14,
Yes.
section 14 speaks about overstaying in India after the expiry of the visa.
Yes.
And also, based on the evidences adduced by the prosecution before the learned trial court, the learned trial court came to a finding that the prosecution failed to establish 468 and 471. Hence, the accused was discharged from the mischief of section 468 and 471. But surprisingly, Lordship, now the petitioner had reported before the FRO when the visa was valid at that point of time. So once the forgery and 471 is acquitted from the two sections, section 14 has got no leg to stand on its own. Because at that point of time visa was valid, now it couldn't be proved that it was forged. So therefore my limited case is that section 14, I cannot be convicted under section 14. With that limited ground, I am before your lordship.
So he was exonerated as far as 468 and 471, except 14.
14.
What does 14 says?
May I read, lordship?
Just one. Yes.
Whoever, number A, remains in any area in India for a period exceeding the period for which visa was issued to him. Number B, does any act in violation of the conditions of the valid visa issued to him for his entry and stay in India or any part thereunder. Number C, contravenes the provisions of this act or any order made thereunder or any direction given in pursuance of this act or such order for which no specific punishment is provided under this act, shall be punished with imprisonment for a term which may extend to 5 years and shall also be liable to fine, and if he has entered into a bond in pursuance of clause F of subsection 2 of subsection 3, his bond shall be forfeited and any person bound thereby shall pay the penalty thereof or so cause to the satisfaction of the convicting court. Why such penalty should not be paid by him? So, Lordship, my submission before this honorable court is that my case falls under section 14, subsection A, overstaying. Overstaying.
Without a visa.
Lordship, yes.
What does the impugn order says? Where's the impugn order?
Lordship, it is at page 66, Lordship.
Page 66 of?
66
of
paper book.
Yes.
Lordship. It is only 3 pages if I may read the entire.
Page 66.
67.
67 is 313 statement.
Lordship, there are 2 paper books. One is
page 71. Page 71. Correct.
Why 2 paper books?
Page 71 also.
Where are the findings on section 14?
Section 4. Lordship will come to page 75. If I may read.
Yes.
Relevant paragraph will be 13. Bottom portion also.
Yes.
This court, on perusal of the passport of the accused person marked as material exhibit 1, on examination of material exhibit 1, this court found that material exhibit is a passport with number so and so, issued on 5th February 2009, and the validity expired on 4th February 2014. Material exhibit 1 reflects that the accused person, Sri Godfrey Albert Decker, is a Nigerian national, thereby not a citizen of India as defined under Clause A of Section 2 of Foreigners Act 1946. On examination of the evidence put forward by the prosecution, it is found that the Office of the Assistant Foreigners Regional Registration Officer, Delhi, extended the visa of the accused person, Sri Godfrey Albert Decker, White Memo Number so and so, dated 15/10/2012. On perusal of the visa in Material Exhibit 1, it is found that the validity expires on 16/10/2012, one day after it was issued. The evidence shows that these raised doubt, and on verification with the Office of the Assistant Foreigners Registration Officer, Delhi, who issued fax message marked as Exhibit 1, it appears that the said visa was not issued to the accused person. From the evidence of PW1, it shows that on 12/9/2011, the accused person left for Guwahati and then reported back to FRO Shillong on April 2012. On examination of the material exhibit at page 9, it reflects that visa was issued on 15/10/2012 and the accused person was permitted to stay in India on or before 16/10/2012. But this court, on examination of Exhibit 3, the seizure list dated 16/9/2012 bearing so and so, found that the passport bearing so and so was seized from the possession of the accused person on 19/6/2012. On examination of the date of issuance of the visa and the date when the passport was seized in this case, this court cannot ignore the discrepancies. The passport was seized on 19/6/2012, but the visa was extended on 15/10/2012, which raises doubt as to the genuineness of the visa. On further examination of the evidence, which is the FSL report Exhibit 5, it reflects that the visa bearing number so and so, page number so and so, was found to be fake one, and it did not give fluorescence when exposed to ultraviolet light. However, from the evidence of PW5, it shows that passport is genuine but the visa is fake. On careful examination of evidence, this court found that the accused person, Sri Godfrey Albert Decker, is not a citizen of India and he remained in Indian territory without valid visa. Issue number 1 is decided in the affirmative. Now, Lordship, if I may go back to my earlier submission, why section 14A in my case is attracted over staying in India. This is clarified by this finding that on careful examination of the evidence, this court found that the accused person, Sri Godfrey Albert Decker, is not a citizen of India and he remained in Indian territory without valid visa. So in my case, this is section 14, subsection A. Now, if I read further, Lordship, page 77, that is the finding on section 468 and 471. On issue number 2 and 3 are clubbed together and discussed for convenience. This court perused section 468 IPC, which lays down as follows.
Yes.
Section 468 IPC, forgery for the purpose of cheating. Whoever commits forgery intending that the documents or electronic record forged shall be used for the purpose of cheating shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable for fine. This court perused section 471 IPC, which lays down as follows. Section 471. Using as genuine a forged document or electronic record. Whoever fraudulently or dishonestly uses as genuine any document or electronic record which he knows or has reason to believe to be forged documents or electronic record shall be punished in the same manner as if he had forged such document or electronic record. On examination of the evidence, this court found that PW6 in his evidence deposed that PW6 did not make effort to trace the name of the person. PW6 is the IO here. PW6 did not make effort to trace the name of the person called Celestian, as accused did not mention the Celestian is from Shillong and neither gave the address of Celestian. Now, Lordship, who is Mr. Celestian? During the investigation, the 161 statement of the petitioner hearing was recorded, and in 161 statement, he stated before the IO, saying that at that material point of time when my visa was extended, because I am a football player, I was injured and indisposed. So there was one Mr. Celestian who used to help all the foreigners for extending my visa by charging some nominal fee. So he has stated that I had given my visa, passport and money to Celestian. So in our statement, the IO says that I did not make any effort to trace Mr. Celestian. If at all this is a case of forgery, he would have been the best person to be quizzed. From the evidence, it reflects that material exhibit 1, which is the passport of the accused, is genuine. However, the visa at page number 5 of the passport is found to be fake. The evidence adduced by the prosecution shows that the accused person left Shillong for Guwahati on 12/9/2011. The evidence shows that when the accused person was asked to report in the office of the FRO Shillong, where he appeared and his statement was recorded, the evidence of PW6 shows that accused person mentioned the name of the person who helped him with the visa extension. However, the prosecution failed to examine the person who assists the accused person in obtaining the visa. The prosecution, through the FSL report, Exhibit 5, proved that the visa is fake. However, the prosecution failed to adduce evidence to prove that the accused person forged the visa or had knowledge that the visa is not genuine but fake. Issue number 2 and 3 are decided in negative and in favor of the accused. In the light of the evidences adduced by the prosecution, this court found the prosecution has proved beyond reasonable doubt the offence under Section 14 or Foreigners Act 1946. However, the prosecution has failed to prove the case beyond reasonable doubt the offence alleged under Section 468, 471 IPC against the accused person.
What is the penalty for section 14?
Section 14 is, I think, 5 years. Imprisonment for a term which may extend to 5 years shall be punished with, shall also be liable to fine.
And how many years was he given?
Here in this case,
Hmm? 1 month.
1 month.
Sentenced to 1 month.
Sentenced to one month. So he has undergone?
No, no. Sentence has been suspended by the order, interim order of court.
So, Lordship, my respectful submission is that, admittedly, wrongly or rightly, when the petitioner had reported before the FRO, the visa was valid at that point of time. At present, it has lapsed because of the trial. Now, once I have been exonerated from section 468 and 71, where is the case, where is the material for convicting me under section 14 also? Overstaying. And here also in this case the petitioner, he had come to Shillong at that relevant point of time to meet his fiancée. Now he is married, he has got 2 children in Shillong. So he wants to respectfully go back to his nation, his country, along with his family, and come back again on a fresh visa. That is my limited submission also. That 14 has got no leg to stand, as because at that relevant point of time, when I reported before the FRO Shillong, my visa was valid, but there was some doubt that it might be forced, and I was using a forced visa. I was acquitted from that.
Yes.
That is my limited submission.
Please, Lordship. Lordship, in this matter, Lordship, the material exhibit, Lordship, it was directed to be produced. And
Yes.
Lordship, I have produced the material exhibit, Lordship. The visa and the passport, Lordship.
But see, Mr. Khanwi, in view of the observation made in the impugned judgment, where the issue of is it fraud and forgery?
Forgery.
468 speaks of
468 and 471.
Forgery for the purpose of cheating
and using a
using as genuine a forged document or electronic record.
So, in view of these two provisions not having been proved, so what would be your stand now?
Lordship, here
Only in the event you make a cross appeal. Have you?
No appeal. No cross appeal. But he has been convicted under section 14, Lordship. Section 14.
Yes, section 14 is. Section 14, as has been submitted by Mr. Gurung,
Yes, Lordship.
is very clear. If
He remains in the
he
area
remains without a valid
with, for a period exceeding the period of visa issued to him.
without a valid,
Section
for exceeding period for which the visa was issued to him.
Yes.
Now,
Here,
so this presupposes that the visa issued is genuine.
Yeah.
The only question here is with regard to the period.
Period. The period expired.
So the period has
He
expired.
claimed to have obtained it, but on clarification being sought, Lordship, it was found that he never obtained the extension. Lordship, I'll point out your Lordship to the clarification from the FRO office.
Yes, Mr. Guru, you have not addressed this issue. You have not addressed the issue that the visa that was issued to you was valid that you have not exceeded the period, covered by the visa.
Lordship, yes, because you kindly look into the FIR. FIR was filed against me on
19 June.
19 June, Lordship. 19 June. And Lordship will kindly peruse my passport and visa that is on recording. It was produced. That was valid till the month of September.
What is it?
2010.
The material exhibit I have produced.
It is even reflected in the judgment itself also.
Reflected in the judgment. Let's have a look at it again.
Kindly come to Lordship, page 76, paragraph 15. Here, Lordship, from evidence of PW1, it shows that on 12/9/2011, the accused person left for Guwahati and then reported back to FRO Shillong on April 2012. On examination of the material exhibit 1 at page 9, it reflects that the visa was issued on 15/10/2012 and the accused person was permitted to stay in India on or before 16/10/2012. So FIR was filed against me in the month of June 2012.
Okay, so
yes,
So within that, you see, at the time the FIR was filed, your visa is still considered to be valid.
Yes, 4 months more.
Lordship, just I'll take your Lordship to this fax message, clarification fax message. I'll come to this visa also, Lordship. Visa. He reported in the Shillong FRO office, Lordship, and the official in the office on checking the visa, Lordship, they found that there are some doubts. So they have written to the FRO office in New Delhi to give clarification, and they received the clarification.
Okay. Let's put it this way: that when he reported to the FRO, within that period of validity of the said visa, there was some doubt expressed by the officers concerned, for which they have sent the visa for clarification or from Delhi.
Yes.
Is it?
Yes.
And thereafter it was confirmed that it is a forge.
Yes.
That is the official version. Forge. But that is exactly the basis, you see, or the issue that was raised in the case.
In the case.
And the court, having gone through all the evidence, appreciating the same, have come to a conclusion that there was no forgery involved.
There is no forgery.
468, 461, 471.
No forgery.
No case has been made out.
No case.
So what do we? So if that is the logical conclusion would be that the visa presented by the petitioner at the FRO is genuine.
It's genuine.
So that should be the picture.
Picture, yes.
If it is genuine and the date of expiry has not yet come,
yes.
So it means that when at that relevant point of time, he is still within that period where the visa is valid. So again, then the issue of Section 14 should not come. You see the
yes, Lordship here, if I take Lordship
except
this visa.
Yeah, except now you see, Mr. coming. If even you go to the issue of the visa, I don't know whether without a cross appeal or then we have to reappreciate the evidence. Whether any evidence is made out that the visa is forged.
Because comparing the seal also, Lordship, the seal in the visa is different from the original seal.
Where is the evidence to that effect?
It's there in the material exhibit, Lordship.
No, evidence. Material exhibit.
Yes,
around?
evidence also, Lordship, the evidence of the FSL expert.
FSL expert.
Yes, I'll take your Lordship to FSL expert also, Lordship.
Friend goes to that.
Was that taken into account by the court?
Yes, Lordship.
That was taken into account, hence the finding.
FSL expert report, its evidence also is there.
My lord, the FSL expert was examined. During the cross, he stated that the original seal of the issuing authority from Delhi was never made available to him for the sake of comparison.
Comparison.
Hence he said that I cannot say which is genuine and which is fake.
What is your version?
Lordship, there is no cross, Lordship. The defense counsel declined to cross, Lordship. My learned colleague, Lordship, he's saying that in the cross, there is no cross, Lordship. My learned, the defense counsel declined to cross.
Let us look at the evidence of
It was not refuted. The evidence of the FSL record was never refuted.
Just let's.
Lordship, evidence is page 52 of the paper book, Lordship. FSL expert reports. Evidence.
Yes, you decline, Mr. Guru.
Yeah,
What is
decline,
this?
Lordship.
Let us read the evidence.
I have received someone to appear before this court today. At present, I am working as Assistant Director, Document Division, Forensic Science Laboratory, Shillong. I have been working in this profession for the last 21 years. Exhibit 5 is the opinion letter prepared by me, and Exhibit 5 by 1 is my signature on the Exhibit 5. My finding in Exhibit 5 is that number 1, the supplied passport bearing number so-and-so was found to be a genuine one. Number 2, the visa bearing number so-and-so on page number 5 of the passport was found to be a fake one. Number 3, the red enclosed question seal impression stamp and mark Q2 does not match with the red enclosed question seal impression similarly stamped and mark Q3. Number 4, no opinion can be given on the authenticity of the red enclosed question seal impression stamp and mark Q1, Q2 and Q3, as no similar specimen were supplied for comparison with the question seal impression. The visa was found to be fake because it did not give light when exposed in ultraviolet light. Q2 and Q3 are seal impression and they do not match on the superimposition because of the difference in the size of the letter as in Q2. The letters are in combination of both capital and small letters, whereas in Q3 all the letters are in capital form. No cross.
Yes.
The letters are different.
Yes. Let me clarify, Your Honor. Why cross was declined here? Kindly come to this. I have received the summons to appear before this court today. At present, I am working as Assistant Director, Forensic Science Laboratory, Shillong. I have been working in this profession for the last 21 years. Exhibit 5 is the opinion letter prepared by me, and Exhibit 5 by 1 is my signature on Exhibit 5. My finding in Exhibit 5 is that 1. The supplied passport bearing number so-and-so was found to be genuine. 1. 2. The visa bearing number so-and-so at page 5 of the passport was found to be fake. 1. Number 3, the red enclosed seal question seal impression stamp and mark Q2 do not match with the red enclosed question seal impression similarly stamped and mark Q3. 4. No opinion can be given on the authenticity of the red enclosed question seal impression stamped marked as 1, 2, 3 as no similar specimen was supplied for comparison. The question was on reference was made to 3 seals that was forwarded to the FSL expert. He cannot say whether they are genuine or fake because no similar specimen.
So the only
not necessary to compare, Lordship, because the seal is in the material exhibit.
How can they be without comparing the original?
The visa.
I think the evidence that was given here, why the visa is said to be fake, is because it does not
give fluorescence.
Yes, give not eligible. Give not
eligible.
not.
I think
did
it's
not
light.
give.
Light. I think, Lordship.
Yes.
It should be light. I think it did not give light when exposed to ultraviolet rays. I think
yes.
Light.
Fluorescent light.
Fluorescent light.
Fluorescent light.
Fluorescent.
In this case, what happened, Your Honor, Your Lordship? The IO never bothered to visit the FRO who had sent the fax message. Secondly, he did not even bother to seize the original seal for the purpose of comparing with the one that is appearing in the visa. And more so, the fax message based on which this FIR was filed, these facts cannot be admitted as evidence unless and until there is a certificate under the IT Information and Technology Act. No certificates as such were produced before the court. So after perusing even this, all the
Why
evidence,
is the certificate required?
also because it was generated from the machine.
What is generated from the machine?
Electronic message from where the fax message was generated.
Or the fax
Message. Once it is to be admitted in the evidence, then an expert who has to certify saying that this was generated by me from such a machine, description of the machine, and it is genuine. If it is found to be fake, then I shall be responsible. That was never done. Now, Lordship,
But
that
you have,
no.
Mr. Gurung, the point, the fact remains that you have failed to cross
Yes. Yeah, I admit that.
If you have failed to cross-examine, that means the evidence as has been recorded in the chief will remain.
Yes.
Unrebutted.
Yes. But in the chief itself, he has said that no other specimen was provided.
There are two aspects of the matter here. You see, you fail to see the other aspect, which has been highlighted in this evidence. The fact that there, you see, as far as the paperwork are concerned,
yes,
as far as the seal is there, being a genuine seal or not having been compared, that is immaterial. Even if we ignore that, the expert, see, he is an expert here. He says that the treatment of the visa has to go through this process of being exposed to the fluorescence light. And having been thus exposed, it shows the impression do not match impression or seal impression.
My lord,
okay.
If I can pause here and submit, even if for the moment we presume that my visa is fake, if it is presumed that way. Now, Lordship, the learned trial court has made an observation that accused in 161 had stated to the IO saying that this visa was obtained for me as I was injured by one Celestian. And because Celestian was never examined by the prosecution, hence I was absolved from 468 and 471. So all this evidence was taken by the learned trial court below. Because even if it is presumed that yes, it is fake, then Celestian would have been the main person, was never examined. On that ground, I was absolved.
No, this Celestian was he made a witness?
There is a prosecution to bring.
No.
Never.
But IO with evidence is there regarding this person. IO evidence is there.
Yes, the evidence is there, but he has to be brought to before the court.
Yes.
He has to be listed as a prosecution witness.
Because, Lordship, I'll take your Lordship to the evidence of the IO regarding this person, Lordship. What the statement the IO gave in the
it was never produced.
In connection with this person. PW6, Lordship. PW6 IO. Page 64. I'll just point out this evidence to you, Lordship. Page 64.
Yes. This is the cross.
Yes, Lordship. I have issued a copy of the seizure list to the accused person. I have recorded the statement of the accused person. During the recording of the statement of the accused, certain names were revealed, who according to the accused had extended his visa. However, the accused could not give the detailed address of the said person. I do not remember about the accused mentioning the name and address of a person from Shillong who had allegedly helped the accused in extending the visa. So I did not make effort to trace the name of the person called Celestine, and accused did not mention that Celestine is from Shillong, and neither gave the address of Celestine. I do not agree that Mr. Celestine is responsible or the actual accused for extending the visa. Mr. Celestine may also be the accused person, as he was named by the accused in his statement before me, but the accused person is also equally involved in the case. So he must be knowing that such person is involving in making fake visa. I have seized the fax message from the SB East Coast Hills, which was sent to him by the FRRO Delhi. This is the evidence, Lordship, in connection with that person. I'll take also your Lordship to the FSL report. As a FSL report opinion is there. FSL report, Lordship.
Yes.
Page 22. Page 22. This is the opinion of the FSL. Serial number 2, passport found to be genuine. And at serial number 3, visa bearing so and so number was found to be a fake one. And also from the material exhibit also, Lordship, if you compare the seal in the first extension, the second extension, also you will see that the seal is different. The seal in the second extension, it is all in capital letters and they are bigger letters. But in the first extension, the seal is in small letters, and there is no extension number also, Lordship. No extension number is not there. And the endorsement of the FRO office also not there. The date is mentioned in the first extension. The date is mentioned. The date of issue.
Where is that? You're reading from?
Lordship.
You're reading?
No, Lordship, from the material exhibit, Lordship. Material exhibit. It's in the seal cover.
Just open. Itu tadi. It was seized from the possession of the. This is the
Yes,
passport.
Lordship, that is the passport. Visa is in page 5. I think, Lordship. It's pasted in the visa passport. That's visa. Visa first extension, Lordship. Your Lordship got it? The first extension of the visa.
First extension is.
First extension, extension number is there. The date of issue is 18/10/2010. Date of issue.
1810, yes, date of issue.
18/10/2010. Permitted to stay in India up to 17/10/2011. The endorsement is there.
Yes.
And the seal, Assistant Foreigner Registration, Regional Registration Office, Headquarter, New Delhi.
Yes.
The seal, this is the seal.
Yes.
And the endorsement of this Guwahati FRO office also is also there, Lordship. And the second extension, Lordship, the next page, second extension, there is no extension number. There is no extension number, and also the seal is different. The seal there, it is all in capital letters. The letters are bigger. The seal of this FRO office, New Delhi.
They are in capital letters.
Yeah. Yes, Lordship. Seal of FRO office, New Delhi. They are all in capital letters, and there is no extension number. No extension number. No date of issue. Only the date of this permitted to stay in India till or before 1610. Permitted in first extension, it's mentioned 1710, the date of the visa.
Yes.
Permitted to stay up to 1710 2011. Oh, yeah. And here it is mentioned till or before 1610 2012.
Permitted to stay?
Permitted to stay
10-10-12.
Yes, till or before 1610 2012.
Yes.
FIR was filed against me in June.
Because it is a fake visa, Lordship. The date is fake, so it was filed that.
So when was this issued?
The date of issue of the second extension, Lordship.
Yes.
It is not mentioned here.
And how?
It is not mentioned. There is no endorsement also, Lordship. Date of issue is not there. Date of extension number is also not there.
Then how was the FIR filed in June?
Because they found it. They found FIR has expired. Because this, according to this, it appears that it is still valid. According to this visa extension, it appears to be valid. But because of these discrepancies and doubts, and the visa, so it is the date it was filed. The FIR it was filed.
You see, you go back to the previous one, that is Q2. It says permitted to stay in India up to 17/10/2011.
2011.
Okay, so before 2011, he should have applied for extension.
Extension.
Which probably he may have. Therefore,
he claimed to have applied.
He claimed to have applied.
Yes.
He may have or he may not have.
Yes. But he got it by fake. Because this is not genuine. According to prescription, it is not genuine. It is a fake one. The seal is different. There is no number.
When you apply for a visa, is there a format? Is there a form, or do you do it by a letter, or how do you do it?
Now the form is there. Online also it's there. A form is there. He claimed, Lordship, if I take Lordship to the evidence of the witness, Lordship, PW1 is the complainant. Here the main witness are PW1, this PW3 and PW5. PW1, Lordship.
Page?
PW1 is at page 33. Page 33, Lordship, PW1 is the complainant. Complainant also examined. Lordship. I'll read it, Lordship. I'll read the evidence, Lordship.
Yes, please.
I am the complainant, 33, Lordship. I am the complainant, PW1. I am the complainant in the instant case. I have received a summon to appear before the court today. Godfrey Albert Decker, a Nigerian national, reported his arrival on 5/9/2011 at the FRO office Shillong. Then he got himself registered with registration number so-and-so dated 6/9/2011, and his visa expired on 17/10/2011. Then on 12/9/2011, he left Shillong for Guwahati, and then he reported back to FRO Shillong on April 2012. On checking of his visa, it was found that his visa was extended by the Assistant Foreigner Regional Registration Office, Delhi, till 16/10/2012. White memo number so-and-so dated 15/10/2012. It raised a doubt as because his visa was extended till 16/10/2012 and date of his granting of visa is on 15/10/2012, 1 day prior to the expiry. Then on 17 April 2012, the office seek a clarification from the office of the FRRO New Delhi, white letter number so-and-so dated 17 April 2012 about the date of extension and memo number in the visa. Then we received a reply by fax on 15 June 2012. White fax number so-and-so dated 15 June 2012, stating that the visa was not issued by the office and the stamp is fake. Then I submit a letter to OC Sardar PS Station, white letter so-and-so dated 19 June 2012, requesting for taking necessary action, and in the meantime, the office informed the Joint Secretary, Ministry of National Affairs, and Under Secretary MHA New Delhi, white letter so-and-so dated 19 June 2012. Exhibit 1 is the FIR filed by me, and Exhibit 1 by 1 is my signature. Cross-examination. I did not visit the FRRO Delhi in person. I did not depute any staff to visit FRRO Delhi. My complaint is solely based on the fax message dated 18/6/2012. We do not have any immigration check posts in East Kashmir district. The dates and all, it corroborate Lordship with the exhibit. And PW5 or SDF FSL expert. And PW3 also, Lordship, is a relevant witness.
This is also suspicious. Yes. If the date of issue is 15/10, how can it expire in one day?
My Lord, in this regard, if I may submit, and I had earlier made the submission that even if my visa is deemed to be forced one, in this case, the Honorable Trial Court, after producing all this evidence, observed that because the IO did not bother to examine one Celestian, hence they could not prove this guilt. Now, my Lord, the power under Section 401 in revision, the power of the Honorable High Court. My Lord, if I may read, it is subsection 3, Section 401, High Court's power of revision. Subsection 3, nothing in this section shall be deemed to authorize a High Court to convert a finding of acquittal into one conviction. Now, my Lord, in this case, I have already been discharged from Section 468 and 471. Now, where is the need to enter into these evidences which was finally scrutinized by the trial court below to come to a finding completely opposite to what the finding of the trial court is? Now we are...
But why have you come by way of revision?
What's it?
Why have you come by way of revision?
Because I had already preferred an appeal before the Honorable Session Judge.
Oh, okay. Now, again, coming back to that, when you have preferred an appeal for the Sessions Judge, so the Session Judge would generally appreciate the... Where is the appellate order?
Yes, it is at... it is at page...
Page 89.
Page 89.
Has the Sessions Judge appreciated the
yes.
Evidence?
Yes.
What is the finding here?
It's at page 100. Page 100, para 24.
Yes.
While appreciating the evidence of the witness, it is observed that PW1 had stated that the accused had reported to his office on arrival on 5/9/2011, and he got himself registered, and when he had registered, his visa was due to expire on 17/10/2011. Then on 12/10/2011, he left to Guwahati and reported back on April 2012. And on checking his visa, it was found that his visa was extended till 16/10/2012 by memo number so and so and dated 15/10/2012, which raises doubt as because it was extended till 16/10/2012 and date of granting of visa. This is a repetition of
Yes.
the observation. One day prior to the extension, and therefore he had sought a clarification from FRO, clarified that the said visa was not issued by the office and the stamp is fake. His evidence was not shaken during cross-examination. Further, PW3 also corroborated the statement of PW1. The main witness in this instant case is PW5, who is the forensics expert, whose his evidence had deposed categorically that the visa after examination was found to be fake because it did not give fluorescence when exposed to ultraviolet light. And the accused had declined to cross the examine this witness, and hence this statement remained unchallenged and rebutted. Further, it is also observed that the accused in his examination under 313 had stated that he had entrusted his friend and had also paid him the money for the purpose of renewing his visa. The accused as well aware that no agent or hired representatives are allowed inside FRO office, and further no payment of money is required for the purpose of renewal of any visa. And this statement clearly shows that the accused had malified intention for the purpose of getting his visa renewed by undue means. Again, it is further observed that the accused had declined to adduce any evidence or call his friend whom he had paid for the purpose of renewing his visa to show that the visa is valid. Therefore, adverse inference can be taken against the accused person. Therefore, in view of the above observation, this court is of the view that the prosecution has been able to prove beyond reasonable doubt that the accused had overstayed without having a valid visa, and the judgment passed with regard to this point that the accused had remained in Indian territory without visa is correct and proper and no inference. Let us now discuss the quantum of sentence imposed under upon the. So that is the finding.
Yes.
How can one's forgery and using a forged document, I am absolved from that? Only limited issue remained before the court was whether by virtue of the visa my stay was after the expiry. Since they could not prove it is, court has found that it was not forged, it could not be proved. I had used the forged visa as genuine, that was also not proved. Now the only limited question before the learned trial court was whether the visa fake or because they found that it is not forged. So they have to only see that whether at the point of my reporting it was valid. So it was admittedly valid.
Yes.
Now in such situation what happens, Lordship? Off the record, Lordship, there are lots of Bangladeshis foreigners. They come here without documents. What does the government do? They don't draw any proceedings. Just take to the border, beat them and let them go. Now, in the worst scenario, what happens? Foreigners from European nations, when they come and they overstay, what they do is, they give them notice, give them exit visa to immediately leave. Because if a person is convicted here, what happens? He has to be escorted by the Indian authority and hand over to his nation where he will be prosecuted again. It will be a burden to the public exchequer. Hence, here what is happening, the petitioner is praying with folded hands, Lordship, that he wants to go with all honor on his own expenditure. And under such situation, the FRO office Shillong, because as he is based in Shillong, can be directed to give him an exit visa to leave immediately. That is the only thing, because at that relevant point of time, when I was here in Shillong, my visa was valid, rightly or wrongly, and court has found that it was rightly. Section 14 has got no legs to stand on its own. Once I am absolved from 460 and 400, that is my limited submission also. Deeply obliged.
Lordship, there is one order dated 7/07/08/2019. This order, Lordship, passed by the earlier Chief Justice. Here, Lordship, the order is whether whether Section 14 can stand independently after the petitioner has been discharged from the
Order dated?
Order dated 07/08/2019. The court had pointed out
Yes,
whether
just a moment.
yes 07/08/2019.
Yes.
The court had pointed out whether Section 14 can stand independently after the petitioner had been discharged from the this offence under Section 468 and 471, Lord.
Yeah, that is, the petitioner will cite the relevant.
Yes. Yes, Lord. But after that, Lordship, my learned colleague had requested this Honourable Court to allow him to argue without
Yes, because-
the judgments.
Because on the last occasion, Lordship, in spite of my best effort, I could not find an appropriate judgment of the Honorable Supreme Court. Hence, I made a verbal request before this Honorable Court. I may be allowed to contest on merit. So, and hence,
That will also be part of your of your submission. Since you have contended that the section punishment under Section 14 per se cannot stand on its own.
Yes.
So you still have to prove your point.
Yes, Lordship.
By way of on the facts and by relevant authorities. But that you said is not
yes,
available.
it's not there. I made before proceeding with the merit, I had submitted, whether Lordship will remember, my learned friend has just now also mentioned that I had mentioned before this Honorable Court, in spite of my best effort, 7 except one Bombay Judicial Magistrate finding, which I cannot rely on under the same scenario. So, Lordship, why I am saying it cannot stand on its own. Section 14 was brought in my case in view of I being charged under 468 and 471.
Yes, that.
When those two goes off, it goes in my favor. Where is the 14 has got the leg to stand?
That is his submission. That means there is no forgery after they have been discharged from that offence under 468 and all. It means that it implies that there is no forgery. So sentence under Section 14 also does not attract.
Technically, of course, but I
have no authority on that.
The facts will speak for itself.
The facts are different.
Have you filed your written arguments?
Yes, I'll file. I may be given a week time.
You have not filed.
I have not filed.
And this evidence.
We have filed. We will file. I have filed also. That is dated. I have relied on certain judgments also. I have enclosed Supreme Court judgments here. 28 November 2022. Oh no, is it? Yes. I have filed. Written.
Yes, Mr. Kharvi, have you filed?
Evidence of PW3 also is relevant, Lordship. PW3.
Have you filed written argument?
Written argument, Lordship. Then I think I'll file, Lordship. I'll just
because you have to refer to the evidence.
Yes.
On similar lines, I have enclosed some authorities of the Honorable Supreme Court. It is with my written argument.
I'll file.
Have you given a copy?
Yes, yes.
I have not received a copy.
Then kindly take.
But
Lordship, I'll file.
then a counsel for the parties. Hearing is concluded. However, the Learned Counsel has sought for some time to file the written argument. Written argument. Accordingly, list this matter till 2 weeks.
2 weeks, Lordship. I'll file. I'll prepare written
Please
argument. I'll file. Oral argument is completed. This matter has been adjourned again and again. As a matter of fact, today I'm not feeling well. I've got flu.
Okay. Thank you for your effort.
Obliged, Lordship.